counsel for the defendants. I had noticed the plaintiff's deposition. Mr. McFarland took his deposition on May 15th, I believe it was. And throughout the deposition, Mr. McFarland was combative, evasive, flippant, and toward the end of the deposition, when I was trying to get him to answer a question, he visibly got very upset. His counsel called a break, and during that break, the witness, as he's walking out to the door, went berserk. Now he showed up at the deposition with a mobility device. It's like a scooter that you rest your knee on, and then you push with your other leg. It's a fairly significant piece of equipment. And as the witness is cussing at me, he picks up the mobility device and he throws it, and it hits the video camera and breaks the video camera.
Okay. Wow. Okay.
And then after that, after he throws the mobility device into the camera, he then starts rushing toward me with the appearance as though he's trying to unzip his pants. At which point his attorney, Tanner Foreman, puts his arms around him and wishes him out the room. And I think the Michael Barnes is here basically to corroborate that story of what happened. On that same day, later that day, I sent an email to Tanner Foreman asking for new dates to complete this deposition. I have not reached my maximum of 6 hours, and so I'm requesting that I be able to finish this deposition. And Mr. Foreman does not respond to me. Subsequently, I noticed the deposition, and Mr. Foreman quashes it. Now, it's just a motion to quash. It's not a motion for protection. And the only basis he gives in his motion to quash is that it was set without conferring with counsel, which is a complete fabrication. Because I've got the email, and I can certainly provide that to the court if necessary, where I'm asking for additional dates, and there's no response.
Can you share screen the email just so I can see it?
Let me see.
Or Mr. Foreman, is this all true? Did everything he's saying true?
Your Honor, we had put in the motion that we weren't available that date. My client wasn't available that date. We understand it's what it sounds to me like is that Mr. Ledyard is asking the court to compel the deposition. That's not what we thought we were here on today. And if we are here on that, we would like an opportunity to brief the court further on what happened on that date.
I'm not following you, but okay.
Well, I guess what I'm saying is I feel like procedurally the proper motion would have been a motion to compel the deposition here today rather than asking for our motion to quash be heard when the date for that deposition passed a month ago.
Well,
all right, this is what's going to happen. Go ahead and share screening just so I can see.
Okay. Are you looking at my email screen?
Yeah.
Okay. Second paragraph, this is also my request to reset your client's deposition that he imploded today. I did not receive a response to this email, and subsequently I noticed it. He quashed it. And I'll also note, Your Honor, that at the hearing we had back on June 21st, out in the hallway, Attorney Tanner Foreman, I asked him again for, I guess I can unshare now. Are you done with seeing it?
Yeah, I can see. I've seen it. Yeah.
Okay. So I asked Attorney Tanner Foreman on the hallway to provide some dates for the plaintiff's deposition. He said he was never going to provide dates for the plaintiff's deposition. And that's just to go ahead and notice it and I'll quash it. So I just went ahead and set this motion to quash for hearing. But I also want to, say a few things about, what happened to this videographer is that basically the videographer pointed out to Tanner Foreman that the video was broken, and Tanner responded to him that he had his information. The videographer has attempted to reach the Adler firm several times to discuss how this camera is going to get replaced. And the Jim Adler firm has not returned any of their calls or emails. I have tried 3 times. I spoke to Miss Garcia in the Houston office of Jim Adler, spoke to her, explained to her the situation, that it was their client that threw their mobility device into the camera, and they need to replace his camera. This is this man's livelihood. And I got the impression from Miss Garcia that they were going to reach out and rectify the situation. And this has been going on since May 15th. And still today, Barnes Videography has not heard a thing from Jim Adler's office.
Mr. Foreman, this is kind of an interesting story. What happened?
Well, Your Honor, so just as a little bit of a background, my client is a disabled veteran with a history of PTSD. He suffered a brain injury in this crash. He has anger issues. He's got a number of other problems. During the deposition, Mr. Ledyard repeatedly tried to trigger him however he could. My client was trying to give an answer. Mr. Ledyard would not allow him to complete that answer, and Mr. Ledyard told him that he needed to shut his mouth. At that point, I asked for a break, and my client was peacefully walking with his mobility scooter out the door, and Mr. Ledyard started questioning his veracity by saying that he didn't have a brain injury, at which point that again triggered my client to where he picked up his scooter and he threw it. And then at that point, I got him under control. Mr. Ledyard said, "Hey, turn the camera back on. Let's keep rolling. Let him see him." Again, my client got upset. I controlled the situation. I got him out of that room. But our position is really, Your Honor, I mean, my client is the one that damaged the camera. He was triggered by Mr. Ledyard. I don't see how personally our office would be responsible for replacing any video equipment because of that. That's our position.
Well, that's about like saying Trump.
Let me ask this. Was this all on film? What happened exactly?
No, Your Honor, it stopped after Mr. Ledyard told him to close his mouth, and I asked for a break, and then the video turned off. And then it was what happened.
Let me hear from the videographer, kind of what does he have on film?
Good morning, Your Honor. I'm actually not the videographer. I'm the owner of the company. Brian Primavera was the videographer. And I have a statement from him if you'd like me to read it.
I mean, I'd kind of rather hear from him, but
I apologize. He's in a deposition today with one of my backup cameras.
Okay. All right, go ahead.
So here's what he wrote me. He said, "Here's the gist of the conversation I had." I'm sorry. This is what I wrote. "The witness was combative and non-responsive all day long. After lunch, the taking attorney decided a new approach and was trying to get the witness to answer. This made him more combative. They took a break, and as the witness was scooting by using his knee scooter, he yelled profanity towards the taking attorney. As the witness got to the door, he yelled more profanity and became irate and flung his scooter and drink into the videographer, table, and equipment. The witness was restrained by his attorney from going after the taking attorney and removed from the room. After a break to see if things cooled down, the witness's attorney returned and said the depo was over and they were not taking the other deposition at 2:30. My videographer pointed out to the witness's attorney that our equipment was damaged, and he only replied that you have our information."
All right, this is a strange situation, to say the least. I don't think I've ever seen this in 18 years on the bench. So let's kind of think through how we're going to move forward on this case. The first one, Mr. Foreman, do you want to move forward on this case? Do you feel like you want to continue to represent this gentleman or
I do want to continue to represent him. I'm just worried with his injuries and his mental conditions. I don't think it would be in his best interest to sit. He already sat for about 4.5 hours for the deposition. And I don't think it's in his best interest to sit for another, hour and a half to complete the deposition. And that's why we wanted the opportunity to file a protective order on that matter.
So this is what we're going to do. And Mr. Barnes, I understand completely kind of your concern about all this. So the first thing we're going to do is we're going to set this deposition, but we're going to do it at the courthouse. I don't want to be in a situation again where there's not security. I do think Mr. Ledyard should be able to finish the deposition if he still has time. So are you guys here both locally, and is the plaintiff local?
Yes, Your Honor.
Do y'all want to do it this Friday, next Friday? Those are two options I could give you. I'd like to do it on a Friday morning, ideally.
Your Honor, I am actually going out on vacation. And on Friday, I have I have something else scheduled, and then the next week I'm after, but I think the 2nd would work if that works for
I can't do. I need to be there, and the 2nd doesn't. I'm not going to be here. So
Would July the 26th Friday be available for the court?
Yeah, July 26th is perfect, but I think he can't. I think you're on vacation, right?
I am, and I have a vacation letter on file.
I'm not trying to stop your vacation. What is this case set for trial? Let me see.
I could on August 2nd. If the court
I can't do August 2nd.
Fridays, I can do August 2nd.
I can't do August 2nd. August 9th I could do. August 16th, August 23rd, August 30th.
The 16th is open for me.
I can do the 16th as well.
All right. Rhonda, are you there?
I think, Your Honor, I think this is a good idea. And one of the things I was thinking about, because after the accident, the gentleman's on the phone with 911, and he's actually talking about potentially wanting being in a mental place where he wanted to shoot my client after the accident. But the 911 operator asked if he had a gun with him, and he said no, that he started laughing, that he had just cleaned it and it was still at home. The court reporter in the deposition, when I saw him reaching for a zipper, she thought he was reaching for into his pants for something. She thought maybe a gun. So I think having this at the courthouse is probably a very, very good idea.
Rhonda, are you there?
Yes, Judge, I'm here.
Can you get Gary?
Yes, just a moment.
So we'll set this for this 16th, August 16th at 9 a.m. I assume that you don't need any help with rescheduling the defendant's deposition. That doesn't need to be at the courthouse, or does it?
No, it doesn't. Mr. Ledyard had said he wasn't going to give us any dates until the plaintiff's deposition had been completed. So we just need to get with him on dates.
Do you want to just do it that afternoon at y'all's office?
Yeah, that works for me.
You know what, Your Honor? I'm sorry. Can we move this to the 23rd?
I want to check to make sure my bailiff's there.
Judge Avon here.
All right. Does the 23rd work for both sides?
Works for me, Your Honor.
Yeah, I didn't properly write on my calendar, but I'm actually taking my daughter to Florida for college. So
Okay.
23rd is good.
All right. Well, congratulations on taking your daughter to college. Gary, just so you kind of know what's going on August 23rd, and put this on our calendar. And Gary, do you know if you'll be here on the 23rd?
Yes, sir, I will.
We have a deposition that where there was some violence in it. nobody got hurt, but they destroyed video camera. And apparently there's been some threats. And so I'm going to have you there in the deposition.
Okay.
We may need an additional bailiff that morning.
Okay.
So if possible, so go ahead and, so as far as you know, you'll be here on the 23rd at 9 a.m. August 23rd.
Yes, sir.
All right, can you just put this both, Rhonda and Gary, can you put this on your calendars and on my calendar, August 23rd at 9 a.m. In this case, we're having a deposition. We'll do it either in the back conference room or in the jury room. I don't think we'll need I'd rather have Gary close by. So that's going to be ordered. So Mr. Ledyard, go ahead and include that in the order. That's going to be on the 23rd in the 68th District Court, in person, videoed. So we dealt with that issue. Second issue is the issue of the camera. Mr. Foreman, kind of what is your position on this? You don't think your firm should have to pay for it, your client should?
That's my position, Your Honor, and the firm's position, I guess I should say.
Ideally, that's not how it would work, but I think legally you're probably right.
I mean, I get, Your Honor, that he damaged some equipment, but I don't think that Mr. Ledyard was without fault in comments that he was making and trying to agitate my client.
Well, that's about like saying Trump's responsible for the assassination attempt, which is false. If Mr. Foreman prefers, then I guess Barnes Videography can intervene into this case and present that information to the jury, which I wouldn't think.
This is my kind of gut reaction. This is not an order if you guys don't agree to it, but what I think should happen, again, not an order, is that I agree with you that it's Barnes Videography, is that what you said?
Barnes Video Group.
Barnes Video Group
Yes, Your Honor.
Can intervene. What I would probably do is bifurcate this. So I don't want the jury to hear this during the case in chief, but after they reach a verdict, I mean, this is just to me the most logical way to do it, that we could hear a separate trial or hearing in front of the jury on the issue of the damage to the camera. That's not the only way to do it. You could obviously file a separate lawsuit. You could, I mean, I've never dealt with this issue, but what seems to make the most sense is to intervene, file a claim, and then but I would not hear it at the same time as everything else. I would hear it as, or either I would hear it or, does that make sense?
Yeah, but Your Honor, John Ledyard here. So, I mean, I would argue that, what transpired is relevant and should be admissible to the jury in the sense that he's claiming injuries to basically all portions of his body, and yet he's able to pick up and throw across a room this heavy mobility device, which I think kind of speaks to potentially toward his non-injuries in this case.
We'll see. I mean, but you don't have a video of what happened, correct? I'm not ruling on anything. I'm just making suggestions at this point.
Okay.
I mean, but I don't think that this is I don't think that based on the briefing I have today, which is just a motion to quash, that I can issue sanctions against Mr. Foreman or his client that they pay for the video. I don't think that I can do that based on what I have before me. So if you want to file a motion for sanctions and brief it, I've just never seen this before where damage was done during a deposition that somebody's requested. You may be right. Maybe that should be brought in. I'm just kind of giving my gut reaction. So you guys do what you think.
Right. It's their client. They signed him up. They can take it out the pot at the end if he gets a pot. The way I look at it, it's the right thing to do.
I don't necessarily disagree, but based on the briefing I have today, I don't really think I have the power to do anything other than I'm going to order the deposition to occur at the courthouse on the 23rd, and we'll make sure we have security there.
Okay. And Your Honor, the last thing I'd like to cover is I've reached out to Tanner Foreman several times about mediating this case, to which he hasn't responded. He finally did over the weekend. Or actually on Friday, I think it was. It says, "We are not interested in mediating." That email was 7/11/2024 at 11:38. We have a DCO that requires us to mediate, and I'm doing my best. I've offered mediators. I've offered dates if they're open. But
Mr. Foreman, you're going to have to mediate. It doesn't have to be in person. It could be.
That's fine, Your Honor. And I don't think your order says that we're being ordered to mediate. I'm fine with attending the mediation if you want us to go. I'm just telling you now, it's not going to be fruitful from the plaintiff's end. And we would like to, work our case up. We've been trying to get depositions and would rather do that than take the time to go mediate.
well, I'm trying to comply with the court's order, Your Honor.
Who's your court order? Let me look it up. Who's your court order mediator?
It's the DCO signed by the court just says mediation shall have occurred by the state September 29, 2023. If the parties are unable to agree, they may petition the court to appoint a mediator, but no one is actually appointed.
That's unusual. Let me take a look.
I don't see there was ever a DCO signed.
All right.
Hang on.
Well, I don't see a mediator. That's unusual that maybe this was a level 3 and we didn't get a mediator in. So we're going to go ahead and appoint Ken Rubenstein to be the mediator, and the deposition is going to take place over Zoom. So Ron, to make sure that it says in big caps, so put Ken Rubenstein and then it over Zoom in big caps. I think he does most of his mediations over Zoom anyway. But
Okay.
all right.
Does the court have a deadline for this, or?
Rhonda, let's say that needs to occur within 90 days.
Okay.
You should be able to get in with Rubenstein within 90 days. All right, guys, get me an order on this, Mr. Ledyard. Make sure that the order says at the beginning that this was heard on July 15th, 2024 over Zoom, and at the beginning, instead of on this date, indicate that this deposition is ordered to take place at the courthouse and that at 9 a.m.
Thank you.
All right, you guys have a great rest of your day, okay?
Thanks,
Okay.
Your Honor.
Thank you, Your Honor.
Mr. Barnes, good luck.
Thanks.
All right, our next hearing is, there's somebody named Brittany Little here who's trying to message me. I'm not sure.
That's me. I'm sorry. I've never done this. I didn't know if I was supposed to check in or anything like that. I didn't know y'all were still meeting, so I didn't want to interrupt. I think
So you have the next hearing. So Linda, let's go ahead. I'm sorry, Tony, let's go ahead and get started. It's DC 23-13515, Wells Fargo Bank versus Brittany Little. Counsel and parties make your appearances.
Carl Smart here on behalf of Wells Fargo Bank.
And then Miss Little, you need to state your name for the record.
Brittany Little.
All right, let's proceed.
Your Honor, this is a summary judgment motion based on a breach of contract for a credit card matter. Along with our motion, we've submitted the affidavit of Kelly Christopherson. She's a longtime employee with Wells Fargo. She's got 3 attachments with her affidavit. She testifies that she is familiar with how Wells Fargo keeps their records, and specifically with Miss Little's records. The first exhibit is the credit card agreement itself. The second is a statement from July of 2022, which shows the final time a payment was made. This indicates Miss Little understood this was a debt, not any type of a gift or a grant, as she was repaying on the account. The final is a statement from August of 2023, which shows the remaining balance, or the balance that we're requesting today, to $27,487.32. This is the final statement prior to charge off as required by the federal government. This statement includes a note that says the account is in default for failure to make payments when due, and that the account will be accelerated. We've also included the affidavit of Tom Sellers. He's another attorney with our office. He's been with our office for about 14 years. He only charges $190 per hour. He's worked a little bit more than 4 hours on this matter. And so we're requesting a total of $800 in attorney's fees, which I believe is more than reasonable and fair. I will note that there's not been a written response that I'm aware of to this matter, so I don't believe that there's a whole lot of other argument that can be given. And with that, I'll let the defendant say whatever she needs to say.
Ms. Little, what would you like to say here?
So I went through a debt. I was trying to reduce my debt, and so I heard of like a company that helps you make smaller payments consistently to pay it off. I was actually unaware of how, I guess I didn't understand that they weren't going to take the payments that I was making to them and pay the Wells Fargo. But I started with a debt relief company, and so I've been paying them thinking that they were paying Wells Fargo. And apparently they weren't. And so when I called to tell them, like, this is not what we agreed upon, they said, oh no, we will send over the proper paperwork to Wells Fargo. And so I have been paying this debt collection company since the date that, I forgot his name, that he said that I was paying the debt company to pay Wells Fargo. They did send me over paperwork to sign for a agreement, a settlement that they had made with Wells Fargo. And the last communication they had was with last Friday, and I signed another motion form and I sent that to them as well. But they told me not to worry, that they were sending everything in and that they took care of it. So I didn't know what this was for, but I got the email, so I showed up. So like I didn't know, but it was supposed to incorporate everything was supposed to pay for like all the legal fees and for I guess the attorney's fees as well, with my debt collection company that I've been paying. So actually, I didn't know what this was in regards to, so I'm now aware.
Are you familiar with this?
Your Honor, I'm aware that she is with a debt collection company, but we have not received, I don't have any notations or anything regarding anything recent that we've received from them regarding this particular matter. If there was a settlement amount that was given and accepted by Wells Fargo, I certainly would have removed the matter from the hearing docket this morning, or at least informed you that we've come to an arrangement and we don't need the hearing as soon as we got here today.
I turned it. I know one time I went. I'm sorry. Am I allowed to speak? I've never done this before.
No, can I ask? You said you have some kind of agreement. Can you just share screen that so I can see the agreement?
Yes. Let me go to my email really quick. Sorry. Okay, so share screen. How do I'm sorry, oh wait, share, I got it. Share screen. Start broadcast. Can you see my screen?
I can, but it doesn't show the document.
I have to go to my email. I'm
There
sorry.
you go. There you go. It just came up. I don't know what you just did, but something came up.
Okay.
Is that it?
Yeah, this was the last communication I had with the company, and they wanted me to share. So it was 6/5 that they asked me to sign a document. It was the conditions form, but this was the second form that I had signed for them. I will go to the first form. I
can't. Let me see if I can read that. It's a little hard to see.
Okay, I'll try to zoom in.
Are you, Mr. Smart, are you with Waddell Serafino?
Yes, sir. And I do see that the matter was settled back in April of this year, but then payments were not made as agreed, which is why we're moving forward at this point.
Did you make all
Oh,
your payments, Ms.
yes,
Little?
yes, sir. I can go to the app. I'm sorry, I'm on my phone, but I can show you
Sure.
on the app that I have been paying them. And I'm gonna use my case. Let's see, my accounts. So it says,
Wait, does this have your, wait a minute, does this have your private information? I don't want this to, this is on YouTube.
oh, I don't, it just has the ending of my bank account and then